So with those legal submissions, Chair, we request that...
What do the cases say?
Let me take you to
You don't need,
the city of Tshwane.
you don't need to quote verbatim. You may just tell us the substance.
Well, it supports a proposition, Chair, that proceedings are not halted pending an intention to bring legal proceedings. It's not halted even if you have brought the legal proceedings, and of course we know here there hasn't yet been a filing of an urgent application. It is a stated intention to file an urgent application. So that's the proposition. Well, let me just say, Chair, if I could just quote this one short aspect of the City of Tshwane judgment at paragraph 74. It reads as follows: it needs to be stated categorically that no aspect of our law requires of any entity or person to desist from implementing an apparently lawful decision simply because an application that might even be dismissed has been launched to hopefully stall that implementation. Any decision to that effect lacks a sound jurisprudential basis and is not part of our law. It is a restraining order itself, as opposed to the sheer hope or fear of one being granted, that can, in law, restrain. To suggest otherwise reduces the actual grant of an interdict to a superfluity. That's a paragraph to which I referred the Commission to, Chair. So with those submissions, we request that the application from the bar, as it were, for a postponement should be dismissed, and that we should be in a position now to proceed with the questioning of Mr. Matlala as has been planned for some time.
I think the questioning would, if we do get there, the questioning would come after, depending on whether the legal representatives will indeed not be here, but the questioning would have to follow after Mr. Matlala, if he's all by himself, has been afforded an opportunity to move his application in person. So we won't, assuming that we are with you,
yes,
we won't straight away go to the hearing of Mr. And again, assuming,
Chair,
I was once misunderstood by counsel, and we had an unfortunate heated altercation, he and I.
We don't want to have a repeat of that. So, I understand the Chair clearly.
Yes.
Of course, and I don't wish to preempt any deliberation and ruling by the Chair and co-commissioners.
Yes. Yes.
My submission is merely putting forward the position of the evidence.
That actually takes us to a request that was made by Ms. Missy when I asked her how things would unfold if, and Ms. Missy requested a brief stand down for her to take instructions. I would assume you have no objection to that.
I have no objection, Chair.
Yes. Ms. Missy?
Chairperson, I did miss quite a bit of your interaction with Ms. Hashim because I was trying to figure out how we're going to reply to the submissions that she's made. Am I going to be given an opportunity to respond to the message that she received? I want to ask that first.
Please do respond, yes.
Firstly, Chair, the only thing that I will say is that those submissions were with regards to from Friday up until Sunday, the filing of our founding affidavit, together with our consultation towards preparing a replying affidavit and the heads of arguments. It does not speak to any interaction prior to that. Secondly, if I'm being challenged on the submissions that I've made to this commission with regards to that on a factual basis. I do believe the timestamps of when I went in and went out, because I was present on Friday and I was also present on Sunday, can be looked at. That will show you how long I waited, where I waited, what happened, and ultimately, for example, at what time I got the opportunity together with my learned friend, Ms. Brighton, to eventually sit down outside of the Correctional Service Center and rather email the signed affidavit. So with that being said, Chair, I can only say that. If I'm being questioned as to whether I'm misleading the Commission or I'm casting a particular view about the Correctional Service Center, I'm not. I was simply saying that the Commission is not aware, and any layperson out there is not aware that they have rules and they keep to their rules. And that has affected how we operated on Friday, Saturday, and Sunday. But if I'm being questioned, the timestamps, and I'm sure they have recordings, the times we signed in, as well as cameras to indicate whether I'm misleading the Commission or not. That's as far as I can take it.
Thank you. There is no way that based on what we are told from the bar, from both sides, there's no way, seeing how contradictory the two versions are, that we can take a decision on that. And in fact, I think for present purposes, it's not even necessary for us to take a decision or to go there at all. Do you wish to reply to the rest of...
Chair, sorry, that threw me off a bit. Oftentimes when you are on the legal representative side and you're being called to question about whether you're lying or not, it does throw you off because it speaks to your integrity as a legal representative. I wanted to, because I believe in our earlier engagement, I wanted to distinguish between the position that's been taken by our client, Mr. Matlala, as well as the arguments that are made earlier on, Chair. So the arguments that I made earlier on are in relation to us, whether we can proceed and why we're saying we should stand out till tomorrow. The second element of it, having come back and taken instructions from clients, those are his instructions about how he feels in terms of us having to proceed. Should you insist that we proceed today and not wait till tomorrow? So there needs to be a distinction between the two. We're not shifting the goalposts from this is what we were saying earlier on in the morning and now we're changing and we're saying this here. What I spoke to mainly, now that we've come back after the stand down, is with regards to the instructions and his observation, how he feels about it. The earlier part still stands as it is, where you are asking us and we have to address you as to whether we proceed or we don't proceed, and you made the ruling that you made, which is that we proceed at 12:30. So I just needed us to make the distinction.
You do still need this stand down with regard to how things will unfold in the event that the decision is we are going ahead.
Chair, we still do need to stand down, but
right.
We had a discussion when we were hoping that it doesn't come off as if we're being hostile, as because it somewhat has underlying for us that, oh, so now you need to go and preempt. Are you going to walk away from us? It gave that impression. But if
no, it's just wanting to know how things are going to unfold. There's nothing judgmental about it, and I have not observed any hostility. I just want to know how, if we do get there, again, underline, if we do get there, what's going to happen?
Chair, I would appreciate the stand down. Chair, I would appreciate the stand down to just really quickly take instruction from client, and then I'll come back with a response if you do decide to otherwise.
Yes, thank you.
Noted, Chair.
Thank you, Ms. Hasim.
Chair, it's very important for me to make one remark.
Yes.
And it's in relation to the message that was received by the area commissioner.
Yes.
My instructions were simply to put it on record.
No.
I take no position on whether my learned friend, Ms. Missy, is misleading this commission or anything like that. That's not my intention, and I do not wish to be misunderstood at all, to be suggesting that. It's simply an objective message that was sent through that I put on record, and I think perhaps what it is from the commissioner's side to say we are not being obstructive.
Yes.
But the fact that it is difficult to consult with a client who is incarcerated, if any of us who have gone through that understand that it's a difficult
Yes.
process. And so I just wanted to make that clear.
An important takeaway actually from that text is this. As Ms. Messi was arguing this morning, I actually did think of the possibility of the Commission engaging with the prison authorities to ensure that the difficulties Ms. is telling us about do not recur. Now, a good take-home or take-away from this text is that such an engagement will actually, there will be no resistance to the request that I already had in mind. Yeah.
Quite so. Thank you, Chair.
I will not indicate it. Yes.
Chair, my learned friend just highlighted something. I did speak about how we often use our cell phones for internet. We use our cell phones to get Wi-Fi through them to connect to our phones. If that request could specifically include that we have our cell phones, because that would really make things easier for us should we have to engage with him later on, to allow counsel at least one cell phone to come in with us. We don't all have to have our cell phones with just one cell phone so that we don't have this issue of internet not being present, etc. Because what would happen is that, for instance, if we need to have a document and he's happy with it and we have to file it, it's just a matter of him signing it, we can scan using our phones. So, and then we would be able to send it immediately and wouldn't have all these issues of we don't have the internet, we need to leave, we need to come back, etc. So I request that you specifically include there that we are allowed to carry in one cell phone for purposes of having access to the internet.
That will be considered.
Thank you, Chair.
I'm saying considered. Let's adjourn. I will not indicate a time.
He said,